3 common misconceptions in sponsoring foreign nationals for employment-based visas or green cards. That's what we're talking about in today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and today I want to talk about some of the common misperceptions or misconceptions, whichever word you want to use, that I have seen employers have about potentially sponsoring individuals for immigration in the United States. So I work with employers and employees all over the United States in many different industries, including the vet med industry, in financial services, information systems, accounting, engineering, all kinds of industries, and across the board. These are concerns that I have heard employers voice, and some of them are well-founded. To be honest, there are reasons that these assumptions exist, but I want to talk about them and break them down because they are not completely 100% true. And this immigration sponsorship absolutely can be a winning strategy for your company. So let's talk about it. The first assumption, or rather misconception or mistake rather, that I see is not planning ahead. So if you are thinking about immigration sponsorship for your business, it is essential to plan ahead. As you can imagine, immigration processes do not happen overnight, which is perhaps one of the reasons that people kind of potentially shy away from the prospect of sponsoring someone for immigration in the United States. But that does not have to be the case. Yes, the processes are not going to happen overnight, but with proper planning, you absolutely can come up with a clear, sustainable roadmap to hire foreign national talent here in the United States. So I'll give you a couple of examples. One example is the H-1B lottery. So the H-1B lottery, and I talk a lot about H-1Bs, we do a lot of H's. It's a commonly used visa classification, but the H-1B lottery happens in March of every year. And there are different timing considerations that you have to take into account. So for example, the lottery is in March, and then the employee, if they're selected in the lottery, can begin working October 1st. That seems like a big gap, and it is, but there's something called H-1B cap gap if the employee is eligible for the H-1B cap gap. So my point is there doesn't have to be that big gap. But if an employee, a couple of things, you want to start planning the H-1B sponsorship, the H-1B registration process, at least in the early part of the year, at least when you get back from the holidays, you want to start that planning process. Make sure that you have an immigration attorney lined up, make sure that you understand the documents that are going to be required, understand who is going to do what in the process, and understand the timelines, and understand what happens if your employee is not selected, or prospective employee is not selected in the H-1B lottery. So those are conversations that really you should start to have now in the fall, or at least in the fall. This is late August 2025. So at least in the fall, start thinking about, as an employer, who do you want to sponsor for the H-1B lottery? If you are an individual foreign national and you need sponsorship, start having that conversation now so that you can have things lined up by early 2026 so that you're ready to go in March. Because some of the saddest conversations I have with individuals or prospective employers are the lottery has happened, like early April. It's not reasonable. It's not feasible to file to have an H-1B registration done in early April. You're gonna have to wait until the next year. So make sure that you are planning ahead and having realistic expectations. The other part of that is having a plan, like I said, if your employee is not selected in the H-1B lottery. So sometimes there are other options other than the H-1B, but they take time and strategy to implement. It absolutely can be done. It's a step-by-step process. It's very logical. It absolutely can happen, but you have to plan ahead. So for example, if your employee is perhaps eligible for an O-1 visa, it takes time to put that together. It's not impossible to do by any means. And honestly, a lot of that work is done by the attorney and the individual employee, not by the employer. But it takes time to put that together, and then it takes time for USCIS to process that. In addition, the L1 could be a possibility. And the L1 is for situations where a person is working overseas and then for a related entity, and then they come to the United States to work. That again takes time and strategy. So it's good to have those conversations early and ahead of time. Again, it doesn't have to be complicated. It doesn't have to be stressful. But it's good to plan ahead and to not assume, to not, make that call to an immigration lawyer right before you need to hire someone, if possible. I know that's not always possible. Another example that I will give is the green card process. So with individuals who are in H-1B status, again, H-1Bs, there's a limit of 6 years in H-1B status. It absolutely can be extended beyond the 6th year in certain circumstances if the foreign national employee is at a certain point in the green card process. So you don't want to wait until year 5. Again, these things take time. So you don't want to wait until year 5 to start having that conversation. You want to have a clear plan. I would say as early as year 2 or 3 in H-1B status, even year 2 in H-1B status. That doesn't mean you have to start the process immediately, but it means you have a conversation, you have a plan in place to begin the process so that you're not scrambling at the end of the 6th year trying to keep your employee in the United States. So the takeaway here from this first mistake in immigration sponsorship is know the timelines. If you don't know the timelines, that is what we are here for. That's what we as immigration law professionals are here for, to educate you, to help you understand your goals and help you come up with a realistic plan. So know your timeline. And then it just becomes part of your hiring process. Once you've had that conversation with an immigration lawyer and talked about, you come up with your strategy about what you're going to do, you know the timelines, the foreign national employee or prospective employee knows the timelines, everybody's on the same page, and you just check off the tasks one by one. And that's what we love doing as immigration lawyers, is helping employers and employees understand the process and then walk you through the process step by step, so you are not alone. The second mistake or misconception that I see with employers who maybe would sponsor foreign nationals for employment-based visas in the US is assuming it's going to be complicated and expensive. And again, there are reasons that these kind of myths or misconceptions exist. It is complicated. Immigration law is one of the most complicated areas of law in the United States, but that's why we're here. You do not have to do this alone. Yes, it absolutely is a complex process. It would be like potentially if I tried to file my own tax returns. I don't have an overly complicated tax situation, but I do own my own business, and I don't know how to do that. That's why I pay a CPA, and they tell me exactly what to do and walk me through step by step. And yes, it's a relationship that I've had for a number of years, and I trust them. And I, I review what we're filing with the IRS, but it's not all on me. So a partnership where you really trust the person that is walking you through the process step by step is absolutely important, and can make a process that seems daunting from the outside go absolutely seamlessly. So the other kind of misconception, the second part of this, is that it's expensive. Yes, it costs money. There are USCIS filing fees, there are visa application fees, there are legal fees for sure. The upside of that is it is an investment in foreign national talent that you otherwise would not have access to. Sometimes employers will say, well, I'm investing in the immigration process instead of a recruiter. I have found this person and I'm willing to invest this money in the process instead of a recruiter. Others use a recruiter and in addition will go through the immigration process because the talent that they have found is that amazing. And I want to point out just something like kind of a soft skill. Yes, it is a way, hiring foreign nationals is a way to find amazing talent that will add value to your company. But it's also a great way to add diversity to your company and interest and complexity and cultural understanding and that type of thing. So that's just a side note. So yes, it does take money. It may not be as expensive as you think it will be. And I laughed just now because I've had people come to me before saying, oh, I think it's going to cost $40,000 to hire this employee. No. There may be processes. I don't charge $40,000 for anything. There may be processes, I can't speak about other attorneys, but no, it is not. Have a conversation with an immigration attorney that you trust before you decide that it is too complex or too expensive, because our job is to walk you through the process step by step and to make it a process that is worth it to you as the employer and for the foreign national as well. The other thing to keep in mind, some of the fees can be paid by the foreign national employees. Others have to be paid directly by, or only by the employer. So it doesn't all necessarily have to be paid by the hiring entity, by the employer. So bottom line here for the second kind of misconception is this process, the immigration sponsorship process, is not about creating headaches for employers. It's not about creating additional stress and worry and anxiety for employers or for foreign nationals, it is about creating a streamlined process where we have a roadmap, we have assignments, we know who is going to do what in terms of getting the process done. It's a clear process and everybody's on the same page. And it's an investment that absolutely is worth your time and your financial investment. The third one is misunderstanding. The third misconception is misunderstanding employer obligations. So I have had prospective employers say to me before, oh, I really would like to hire this foreign national, but if I do that, I'm not going to be able to terminate them if it doesn't work out. Or they will say, I want to hire this person, but then I'll be responsible for them for as long as they're in the United States. That simply isn't true. So again, have a conversation. If you are interested in potentially sponsoring someone for immigration here in the United States, have a conversation with a qualified immigration lawyer to understand exactly what your obligations will be. Your obligations do vary depending on the type of visa that you are using, the type of visa that the person will hold. But keep in mind that employment laws that apply to all of your other employees also apply to this person. So that includes termination. If you, in Virginia, we are an at-will employment state, so you can terminate a person for the same reasons or not reasons that you would anybody else, even if they are here in immigration, on a particular immigration visa. Of course, have a conversation with your immigration lawyer because there are certain requirements that you have to fulfill. So for example, if a person is on an H, my video 2 weeks ago was about an H-1B, the employer's obligations if they have a layoff. Yes, you have to notify USCIS, you have to withdraw the LCA, and you have to offer return airfare home. If a person is on an R1, which is a religious visa, you have to let USCIS know. So yes, there are certain requirements, but it is not overly complicated, and the same employment laws apply to the foreign national that you're hiring as any other employees that you might have. In addition, we talked about the termination. There's something else I was going to say about the employment laws, but the same employment laws apply. There are additional requirements for some, like I said, for some visa classifications, and it varies depending on the visa classifications. Some are more stringent than others. So I've talked a lot about the H. The H does have, you have to pay a certain wage. That's true of the E3 and the H-1B one as well. But again, it's critical that you partner with a qualified immigration lawyer who will walk you through the process step by step and who will tell you exactly what you need to do to comply. Compliance is a huge part of our practice. Advising employers on proactively, when we file a petition, we say, hey, these are the things you're going to need to do, and then reminding them along the way as things roll out. I just had an email a few minutes ago from a corporate client that said, hey, we're increasing the wage for this person. Do we need to do anything? The answer was no, which is great. I'm sure the client loved that answer, but we're helping them along the way to make sure that they are in full compliance, which is really critical. So the compliance piece does not have to be complicated. As long as, again, you're working with immigration counsel that has a clear understanding themselves and is proactively educating you, it can be built into your workflow and your systems, just like your I-9 compliance and other HR compliance that you have to do. So it does not have to be complicated. So I hope that you have found this information helpful. If you take anything away from this, I hope that your takeaway will be that immigration sponsorship does not have to be complicated or expensive. The payoff is you have skilled foreign national talent that you may not otherwise have access to, who adds value in your team in multiple ways. Like I said, not only as a business, as a member of the team from the business sense, but also just culturally, it's fun, I believe, to have, or can be, to have a foreign national on your team. So make sure that you plan ahead. The takeaways here are make sure that you plan ahead. Know that it is going to take time, but you can have a clear process mapped out, and it is absolutely not impossible to do. You can have a clear roadmap and a plan. Make sure everybody is on the same page. Everybody has realistic expectations. That's absolutely critical. And understand your obligations as the employer, but no, it's not complicated. It doesn't have to be complicated, and it can be built right into your existing workflows. So I hope that you have found this information helpful. If so, I hope you'll share this post with a friend or colleague, and make sure you subscribe to this channel so you don't miss our next video. My name is Emily Sumner with Sumner Immigration Law. We serve employment-based and family-based clients from around the United States and around the world. If you are an employer or employee, and if you have questions, If you would like to set a time for a consultation, please feel free to contact us. Feel free to put questions in the comments here and I will answer them if I can. Otherwise, feel free to set a time for a consultation or send us an email and we're happy to help as much as we can. We're here to help and to serve you. Again, Emily Sumner from Sumner Immigration Law. Until next time.